Hello and welcome to today's session. This session will introduce you to the agency's recently published guidance on seeking prior authority for expert witnesses. The new guidance was introduced by Circular LSA1126 and is now available on the agency's website. The guidance is operational for all applicable authority requests received on or after the 6th of July 2026. The agency undertook a significant project to review our approach to authorities processing, following feedback from practitioners, experts and our own staff. We also had to ensure that our approach was compliant with the requirements of the Procurement Act 2023. As part of the review, we have analysed information contained in LAMS and reflected on feedback from all stakeholders. We have also considered the approaches to authorities processing in other jurisdictions. Our hope is that this change to approach set out in the new guidance will reduce the administrative burden on all stakeholders and speed up our processing by reducing the number of queries which are issued. The costs of authorities represent a very significant proportion of the fund, with over 7,600 applications being received in 2025-26, resulting in a committed spend of over £12.2 million. All of the guidance seeks to ensure administrative efficiency while still maintaining value for money. The new guidance applies to all requests made on or after the 6th of July 2026, except those requests falling under an existing general authority and requests for an interpreter or translator, because those are dealt with under a separate process. The guidance applies to both the civil and criminal legal aid schemes. However, we do acknowledge that the Crown Court rules do not require a request for prior authority, but as this is the practice adopted by most practitioners to seek a prior authority, we have included it within the scope of the guidance. All current general authorities remain in force and are unamended by this guidance. To assist you in determining whether your request falls within one of the existing general authorities, we have published a list of operational general authorities alongside this guidance. Any requests received on or after the 6th of July 2026 which are not compliant with this guidance will be queried and 21 days given for resubmission. Failure to resubmit will mean that the application will be withdrawn. In preparing this guidance, the agency undertook an analysis of a significant bulk of management information derived from LAMS. From this data, we identified the most frequently sought expert types and analysed trends in terms of the number of hours and hourly rates sought by those experts. From this information, we then developed an upper limits table, which we have published alongside the guidance, which sets out the maximum number of hours and the maximum hourly rate that we would expect to authorise for each of the most frequently requested expert types. Where the expert you are seeking is on the upper limits table and their estimate falls within the parameters for hours and hourly rate set out in the table, then the agency will only require you to produce one estimate in order to inform our consideration of your request. This marks a significant change to the agency's previous approach, and it is hoped that this will alleviate the administrative burden on practitioners and experts, and will also speed up our processing by reducing the number of queries that need to be issued to chase the production of alternative estimates. Where the expert you seek is not on the upper limits table, or when they are in the table but their estimate exceeds the upper hourly rates or the number of hours which can be approved, then there is an alternative process, which I will discuss later in this presentation. By way of a practical example, if you have a case where you wish to instruct an educational psychologist, you should first consult the upper limits table. The table includes educational psychologists as an expert type and indicates that the agency will authorise up to 16 hours at £100 per hour for this type of report. If your estimate comes in seeking 12 hours at £100 per hour, then you will be able to make your request on LAMS and upload only one estimate in support for consideration by the agency. There are 4 distinct pathways to a grant in the guidance. First, if your request falls within any of the general authorities or is a request for an interpreter or translator, then this guidance does not apply. As set out before, we have published a list of the currently operational general authorities alongside this new guidance to assist you to identify whether your request falls within these or not. Secondly, as previously discussed, if your authority falls within the types of experts and under the upper limits for hourly rate and hours sought set out in the upper limit table, then you should make your application on LAMS uploading one estimate. However, where your request falls outside of the table, either because the expert type is not listed or the hourly rate or hours sought are above the set out upper limits, then you will need to consider one of the 2 final pathways. Where the total amount requested by way of authority is under £10,000, you will be required to produce 2 comparative estimates. Where the total amount is more than £10,000, you will need to produce 3 comparative estimates. This is to ensure compliance with the requirements set out in the Procurement Act. Aside from the number of estimates required, the agency has taken the opportunity to clarify a number of matters in this guidance, which we hope will assist you to make applications which can be readily determined by our adjudicators without them having to be returned under query. The key takeaway here is that your application should contain all of the information that an adjudicator will need to make a determination against the statutory framework. If the information is available at first instance in your application, then this will avoid queries issuing and hopefully speed up processing. So, where the required number of estimates cannot be provided, you should give a full explanation on the face of your application with supporting evidence as to why they cannot be produced. You must set out clearly why the evidence or the report is required within your case. And if you are relying on Council's opinion or direction, this must be uploaded as a supporting document on LAMS and appropriately labelled. Please note that Council's opinion or direction should be contemporary to the request. Where an expert is directed by the court, you should upload the court order and label it on LAMS within the supporting documents, but noting that the fact that an expert has been directed by the court does not guarantee authorisation by the agency. In cases where there is a joint instruction of experts, your application should make clear the percentage that is being sought against your client's certificate and an indication of whether the other parties to the instruction are legally aided. The agency recognises that the previous process of seeking 3 comparative estimates in all cases caused an administrative burden on yourselves as practitioners and on experts. We appreciate that there could be circumstances where a practitioner is working in an area of practice where they are frequently seeking reports of a similar nature from an expert across various cases. For example, you may be a personal injury practitioner who frequently seeks an initial report from an orthopaedic consultant in relation to bony injuries. Previously, we would have required you to produce estimates from experts which named the assisted person on the face of the estimate to confirm that the estimate was bespoke to them. However, in a significant change to our approach, the agency will now be willing to accept a comparable estimate from another case in these more generic report types, provided that it is no more than 12 months old and that you confirm on the face of your application that the expert remains willing to undertake the work at that rate. However, we do reserve the right to seek an alternative estimate by returning the request under query. We are hoping that this approach will mean that practitioners will not need to return over and over to an expert seeking individualised estimates for reports which are more routine in nature, and where often the expert has a standardised rate for the production of initial reports. Obviously, where a bespoke report in a more niche matter is required, we will require to see an estimate reflective of this. We also wanted to make clear our approach to more than one estimate coming from the same source. For example, a medical chamber which has a number of experts of the type sought attached to it. The agency does not consider more than one estimate from the same source to be comparative, and where these are produced, we will return the matter under query. However, where you are unable to obtain any other estimates other than those from the same source, please make this clear on your application and produce evidence, and we will consider this in the wider mix when determining your application. Each and every request for an authority, either within the civil or criminal scheme, is proofed by our team against the relevant legislative framework, but always against the background of seeking to establish value for money and taking into account the total cost involved. The guidance also clarifies our expectations in terms of the format of estimates. It makes our processing much smoother when we are able to identify easily what is being sought by the expert on foot of the estimate. Please therefore ensure that when uploading an estimate it is properly labelled on LAMS. Please ensure that the estimate sets out the hourly rate which is being sought for each aspect of the work to be undertaken. Include the maximum number of hours required to complete each aspect of the work, and where reading is to be briefed to the expert, please set out an indication of the page count, the approximate page count to be briefed to the expert. Please ensure that estimates contain the expert's court attendance rate and confirm whether the cost is inclusive or exclusive of VAT. As the agency will use data within LAMS to keep this guidance under review, it is vital that the information entered by yourselves in the request is accurate. Please therefore ensure that you complete the request as per the prompts on LAMS. Where an estimate is based on an hourly rate, please enter the number of hours in the quantity number of hours section, and then the hourly rate sought in the item cost hourly rate section. You will see an example on screen of 12 hours being sought at the rate of £100 per hour for a psychologist report. Entering the data in this way allows us to analyse the trends in requested rates and hours across expert types. If you enter it incorrectly, for example, if you enter 1 under quantity and number of hours and £1,200 in the item cost section, this will make it look like the expert is seeking £1,200 per hour, which will then distort all of our management information. Where an authority is based on a fixed rate, for example, a police report, please enter the quantity of 1 in quantity number of hours section, meaning 1 report, and the fixed cost in the item cost hourly rate box. Please also be sure to confirm whether VAT is applicable, as this will ease the process when it comes to seeking payment. Under the new guidance, there is another significant change as to how we will describe your grant. Currently, you will see a grant narrative of, for example, authority to instruct Dr. X for 12 hours at the rate of £100 per hour, and the narrative may go on, being 6 hours reading, 2 hours examination, and 4 hours to produce the report. Going forward, the agency will grant using a narrative which is much shorter in nature. Grants will indicate that you have authority up to a maximum value of X pounds. The grant will not specify the name of the expert, and this means that should your chosen expert become unavailable, you can transfer the instruction to another suitably qualified expert without seeking further authority from us, as long as the new expert will not exceed the maximum value of the grant. This should reduce the number of requests which you are required to make. However, where you transfer an instruction, please provide a brief note of the reason for same when you are seeking payment, because this will assist us with our data analysis. However, where this facility is misused, this easement may be withdrawn. Following on from the grant of an authority, if the expert requires additional hours to complete the instruction, we will require a full explanation from both yourself and the expert as to why this work was not foreseen in the original estimate, and we will require a justification for any further request for hours. So if your expert is named in the expert types upper limit table, but is seeking hours or rates which exceed the stated maximums, what should you do? In that instance, you should make your application on LAMS and upload the required number of estimates, remembering if less than £10,000, 2 comparative estimates are required, or if more than £10,000, 3 comparative estimates will be required. You should also upload a detailed explanation as to why alternative rates should be applied. While we cannot prescribe all scenarios where this will be granted, there are a number of factors that will be taken into account. For example, if the report or evidence is of such complexity or novelty that there are only 1 or 2 experts who can prepare the report and they demand a higher rate, then we will consider this. However, we would again ask that you make this clear on the face of your application, as this will negate the need to return the matter under query for your submissions on the point. Similarly, where you have made efforts to obtain an expert whose costs fit within the parameters of the table, but this has proven to be impossible, then we will consider alternative rates. Again, you will need to make this clear in your initial request to avoid a query being issued. The agency are happy to work pragmatically in this regard, but we would ask that you provide us with as much information as possible to allow us to make our determination. It should be noted, however, that practitioner preference for a particular expert or their involvement in a similar case will not be considered to be an exceptional circumstance. The key takeaway here should be that where you are seeking to go outside of the upper limits for experts named in the table, we will require fulsome submissions and evidence as to why this should be authorised in the particular case. So what happens if your expert is not listed on the table? Not all experts are included in the table, and this is because we did not have enough data in LAMS to produce indicative parameters for hourly rates or hours to be granted for that expert type. In this instance, you should make your request in the usual way on LAMS, confirming the need for the report, supported, if applicable, by Council's opinion or directions. Depending on the total value of the authority request, you should upload the appropriate number of comparative estimates, remembering that it is 2 comparative estimates for authorities under £10,000 and 3 for those over £10,000. If the requisite number of estimates is not available, you should set out an explanation for this, including evidence of the efforts undertaken to find suitable estimates. Please set out on the face of the application any unusual or distinctive features in the case which would justify the hours or the hourly rates sought. The agency appreciate that there will be cases where either there are no experts in Northern Ireland in a particular area, or where the instruction of a local expert would not be appropriate. However, to protect the fund from unnecessary costs, outside of jurisdiction experts should only be instructed where there are no local experts who are suitable for instruction. We will expect to see efforts to instruct a Northern Ireland-based expert before seeking an out-of-jurisdiction expert, and this should be uploaded as a supporting document on LAMS. Where possible, experts from outside of the jurisdiction should give their evidence to the court by way of remote link to avoid additional travel costs. However, we do appreciate that the format of evidence will often be determined by the judge. Where costs are to be incurred in setting up a remote link, then this should also be sought by way of prior authority. The agency have also taken the opportunity as part of this guidance to set out our position in relation to matters where costs will not be approved. Costs for research or to allow an expert to undertake additional training or professional registration to allow them to produce the report will not be paid. Experts' administrative costs, such as the costs of secretarial provision, photocopying, courier's fees, or fees to obtain a consultation room, will not be payable. Cancellation fees will also not be payable, and this must be confirmed to the expert within the instruction. Similarly, standby fees will not be paid for court attendance. The position in relation to VAT payable on disbursements is governed by Circular LSA1124, which is unchanged by this new guidance, and that circular is available on the agency's website. Where the expert seeks travel time and travel costs, this should be noted on the face of the estimate. Prior authority for these costs will be required where a Northern Ireland based expert's costs will exceed £200 or where an out of jurisdiction expert's costs will exceed £800. Court attendance fees both for full and half days should be noted on the face of the estimate. It is unlikely, however, that court attendance will be approved in tandem with an initial report, unless there are particular circumstances in the case, which you should make clear on the face of the application. When it becomes clear that court attendance is necessary, an additional prior authority should be sought, noting the previous slide where cancellation and standby fees will not be covered. As with all expenses, vouching documentation will be required when seeking payment. Following completion of the instruction, you will wish to make a payment request to cover the expert's costs. Practitioners are reminded that interim payments can be sought to pay for experts' fees, and separate guidance is available on the agency's website on how to do this. All payment requests will be considered for reasonableness in light of the authority granted. With your request for payment, you should upload the letter of instruction to the expert and any addendum to this, the expert's invoice setting out clearly the hours and hourly rates with a breakdown of work that has been undertaken, including reading time and the number of pages, time spent on consultation and the time spent preparing the report, and details of the length and purpose of the report, along with the dates the work was undertaken. Please also upload any court orders relating to the invoice, and if relevant, please provide details of all of the other parties if it is a joint instruction. As set out before, if the expert you have retained is different to the expert you originally sought authority for, please provide a justification for this deviation in the payment request, and please provide vouching receipts for any disbursements. The agency intend to keep this guidance and the parameters set out in the expert types upper limits under review, and the aim is to ensure that this guidance keeps track with current practice. Reviews will be based on data within LAMS, and this highlights the importance of accurate applications being made as set out previously. Circular LSA 1126 and the new guidance are now available on the agency's website. Should you have any queries, please direct them to the appropriate team using the email addresses set out in the Circular LSA 1023 or via a LAMS message on your individual case. Thank you for your engagement today.